specifically ordered in a federal case. Or maybe it's something that is a case where a state court action where a judge is going to order it because they don't want to deal with all your discovery issues as it relates to e-discovery. So we're seeing these more and more often. So why do you even consider meeting? What's the purpose of this? Why would we want to go through this process of Confer? Well, there's a lot of good information. There are helpful things that you can get out of the way early on if you are able to do a meet and confer. So we get into a meet and confer session, start something where the court has ordered us to sit together and talk about what it is we're dealing with. It's an important starting point to understand what are we going to potentially be dealing with in terms of e-discovery. So Sean, if you can forward a couple slides here.
Yep.
So in the federal rules, if you back up one slide, please.
I just jumped ahead.
Yep. So under the federal rules, there is a requirement to meet and confer. And this is a good starting point because, again, if you're in a state court and maybe these rules aren't specific or are applying in the same way, oftentimes the state court judges are going to apply the same principles in asking you to sit down and try to work through your discovery issues before you bring them up to them. So what does this Rule 26 meet and confer provision require you to do? Well, it requires the party that's going to be producing documents. And in most cases, the plaintiffs are typically on the receiving side of the documents and electronic discovery. And it requires them to come. So if we're talking about the defense in this case, it comes to come prepared with the name and addresses and phone numbers of people who may have relevant information. So number one, they're supposed to come with a list of people to say, hey, based upon what we know about the case at this point, based upon what we understand are going to be the facts at issue or the issues in the case, here's some people we think that we might need to go after some data from. Now, I know the initial thought on that is how honest are they going to be about it? How thorough are they going to be? Understood, but you have to have a starting point. Their client is going to know their organization, their structure better than anybody. This gives you a starting point to sort of jump off from. So they have to come prepared and say, here's who we think we might have to go after. But in addition to that, they also have to describe the documents, data compilations, other things that these people may have or the company may have that you're going to have to deal with in terms of e-discovery. So in the starting point of one of these meet and confers, the obligation really is on the producing party to say, hey, based on what we know at this point, here's the people who I think are going to be relevant. Here's the documents that I think are going to be relevant. And your conversations are supposed to be around how do you most efficiently get to that? How do you balance out the necessity of going through perhaps large amount of information to get to something that's proportionate to the case? But I start this off by saying it's their obligation to come in and provide this basic information to kick this whole thing off with. So we start with this. And, is this the way every meet and confer goes? Do they come prepared with this stuff? Absolutely not. And this ends up being a fighting point from the very beginning. And I think one of the frustration points that a lot of plaintiffs' attorneys have is that they either feel they're being pushed in a specific direction in terms of discovery, and is this a way to, sort of hide the ball and keep you away from looking at what's actually relevant information, or they're asking you to make decisions upon data sets and structures and organizations that you just have no idea about. They're not your client. How are you going to know, what's the best way to do this? But what I think is important in starting off this process is understanding, again, they need to come armed with some basic information, and you need to be prepared to be basically knowledgeable about e-discovery in general and what is the things that we should be doing to work our way through this so that you can have meaningful discussions. And I've seen the conversations turn very quickly when defense counsel or the producing party knows that they have an opposing counsel who has a little bit of knowledge or has somebody with them who has a little bit of knowledge, that they aren't going to just, make a decision and say, this is how we're going to do it. You see the conversations turn to become much more collaborative.
And Pete, it's fair to say too, right, that from opposing counsel, from a defense standpoint, there's really different strategies that they can go with. We talked about this offline, just in terms of, sometimes they will just overproduce, right? So they'll just say, okay, well, what are you asking for? Here's everything, good luck. It's kind of like a data dump, like we call it in the industry. I know, big companies like Apple and things like that have been historically known to do things like that in the past. And then there's the idea of what you were hinting at earlier, which is just underproducing, like really saying you have to specifically, give me examples for this, and this. So also coming to the table with an understanding of why you're asking for certain things is going to be very important. Especially if it's getting, ruled on or anything like that, it'll definitely be very important to tell you why you're looking for what you're looking and have a reasonable reason that you're looking for that.
Yeah, and tailoring your requests to not be completely broad. If you say, I want every email your company has generated in the last 15 years, and if it's a big company, that's unreasonable. That doesn't make any sense. Logically, it doesn't make sense that every possible person in a company is going to be relevant. So you have to be prepared to give and take a little bit. And part of that comes with knowledge. And I think those broad requests typically come out of, one of two things. It's either a fear of, hey, they're going to hide the ball somehow, or I don't know what I'm supposed to be asking, so I'm going to ask for everything. And that can be just as dangerous as getting nothing because, with the amount of data we're talking about here, in some cases, it just becomes unmanageable. So where should a plaintiff's attorney start? So where we want to start is we have to be willing to engage in conversation. We have to be willing to talk to opposing counsel about what might be reasonable or not, and we have to come with some starting questions. The starting questions are, if they haven't already provided it, all right, who do you think is relevant, and what data sets and documents do you think we need to go after? I get accused all the time in my business of punting, and this is a perfect example where punting can really be used in your benefit. You're going to come into some company, and let's just say it's a products liability case. So we'll use a couple examples as we go through these slides today. So let's say it's a products liability case. The issues are about manufacturing dates, suppliers, and distribution. Generally, that's what the areas of issue that we're dealing with. So if I know that going into a case, and I understand that, this is what we're dealing with, there are areas that I should be willing and able to exclude. Maybe HR isn't relevant. Maybe another division of the company is completely irrelevant because they didn't touch the product that we're talking about. Maybe marketing is irrelevant. So we need to be able to go in and say, I understand there are some things that I should be reasonably able to logically understand that I don't need to get into these areas because they don't have anything to do with my case, and only focus on the ones that are potentially important. So the punting aspect, as I mentioned a minute ago, can be very valuable by saying, hey, we know the issues in our case have to do with manufacturing dates and suppliers and distributions. Who should we be looking at and why? That doesn't mean you're agreeing to it, but it's a starting point, because otherwise you're essentially starting from ground zero and figuring out how the organization is structured. You may have some discovery that's told you an org chart or whatever, but that doesn't mean you understand at that point who's the people who have relevant information. So making sure that sort of punting point can have some value in it. It also gives you sort of a litmus test of how reasonable, how trustworthy potentially is the other side, and how their initial response is. If they say, well, we don't have anything, there's nobody relevant, this is a ridiculous case, da, da, da. All right, you're not going to get very far with them without a lot of pushback, versus someone who says, I'm going to go find out, and comes back with meaningful answers for you. So we want to first understand basically, all right, understanding a little bit about the structure of the company, who's potentially relevant, what data areas are under their sort of purview. But then we also want to start thinking logically about document types. And what's this mean? Who's your defendant in your case? Are they an individual? Are they corporate? Is it something in between? Because, that alone will tell you what should you be considered targeting. On the screen here, we can see that, personal defendants are going to have emails, phones, social media accounts, cloud storage, home computers, typical stuff that you as an everyday user of your phone and your computers are going to have in use of any point in time. Where you're getting into corporate defendants, obviously you have a lot more areas that you need to consider and play that, your typical individual defendant isn't going to have to worry about. So understanding your defendant and saying, all right, so if we're dealing with a corporate defendant, we know we're going to have to potentially hone in on certain areas or focus in on some broader scope versus somebody who's an individual defendant, obviously comes into play here, so that when we're looking at someone, we can understand. You also, again, tying back to the type of the case, if this is an accident, And Sean mentioned earlier about, cell phones and accidents. If it's an accident where we have an individual who runs into an individual, maybe they want to know what that person was doing on their phone at the time of the accident. That clearly can be relevant and a fruitful area to check. Were they texting? Was somebody looking at videos? Were they doing something else? Is emails likely to be relevant? Much less likely. Is cloud storage of certain things likely to be relevant? Not much, not very likely. So again, the facts of your case, the things that you're dealing with, the issues at hand are all going to help drive into saying, all right, we understand where we need to potentially look at without even getting into the context of the records yet themselves.
And then, any trend, like before we jump into this with the any trends and information sources, one thing to remember is that we do things differently. So, back in the day, I remember, Pete, it was very simple just to go in and collect companies' email. Well, a lot of companies have moved to things like Slack or things like WhatsApp, even texting and things like that are basically apps that are on their mobile devices that are part of their company community culture, Slack channels, things like that. So really, when you're looking for that type of information and those type of sources, make sure that you're covering everything, not just what you would think like, hey, like, let me get your company email. How do you guys communicate? What else is available? What else is out there? Because if people are communicating on Slack all day, we're going to want to make sure that we're pulling that in as well.
Right. And this is a moving target. The reality is that in today's, fast-paced world of how technology is changing every single day, you can't be stuck with a standard set of questions and interrogatories or discovery requests. It just doesn't fit. And so when we're looking at trends, to your point, Sean, cell phones really need to be considered in every single case. There is potentially relevant information that you could think of if we sat here and talked about every type of case. Someone's use on their phone is potentially relevant to anything. So that's something you can't ignore in any case. More move to cloud products, so more and more when you're using applications out there or buying into a software package, you're essentially renting it, and you're renting it on the cloud, and you're renting cloud storage to go along with that. And that's on purpose by these companies. That's how they make money. They don't want to sell a piece of hard software once and not be able to have recurring revenue off of it. They're selling subscriptions. So to be able to consider cloud storage options, particularly in businesses, is an important piece of what you need to be considering. And then communications, the way people communicate is changing every single day. And Slack or WhatsApp or Instagram or TikTok or whatever it is that you might be the flavor du jour of how people are communicating today is going to be different in 6 months from now. So it's something that you always have to be considering. And, the more stoic or sort of historic the communication mechanism like email is, the less chances you're going to get real-time sort of truthful sort of communications like you do with something where people aren't stopping and thinking about what they're putting into the phone or communicating with someone else. So some of those new communication methods can become very important to be considering in any of your cases.
All right. So with all this data out there, obviously one of the biggest questions and something that comes up frequently with phone collection is, what do we have to do? What do we need to consider for these different methods of collection?
Okay. So collection, as we're describing it here, is, you're talking to the other side about, what discovery you may have to deal with, how's it relevant, and are you going to go after it? And we'll get into more detail about how to search that stuff. But one of the areas that often gets overlooked is how is this information to be collected? And the reason why this is important is because when we're dealing with electronic data, just in the way that we move it can cause all kinds of problems in changing the metadata on the files. So, if you've got an individual client and they've got a bunch of records and they want to give them to their attorney to say, I don't know, here's my folder of stuff, and you turn it over and pass it along to whoever you want. How are most people going to do that? They're going to copy and paste it. And that's how we know to do it. However, just in moving a copy and a paste of files like that, the date those files are created will inherit the date it was copied. So it's no longer relevant to the date that the file was actually created. It considers the creation date the date of the copy. maybe that's important, maybe it's not in cases, but when you get into matters where you have lots and lots of documents and dates do become important, you've just essentially wiped out one of your date fields to search off of, one of the ones that can be very important. So this collection becomes very critical in how you move these things. And again, if you're exchanging 100 documents and what's important is the context of the documents and you can read it and the dates aren't that important, this isn't a big deal. But you get into millions of documents, you get into thousands or hundreds of thousands of documents, and you do need to be able to see this kind of information. It becomes very important how it's collected. And then you get into other sort of information sources. We talked about phones. Really, there isn't any other efficient way to capture a phone than to do a forensic imaging of it. You need to do that. And that preserves all the data that's on the phone and allows somebody to go in and pull out text messages or call logs or activity on a phone and things like that aren't always necessarily going to be instantly available to an end user. And clearly your end user is not going to be able to easily export a whole bunch of text messages out of their phone. So a forensic image allows you to do that. And then if your case deals with something that relates to what happened with data on a computer. So we use an example of, an employment case where somebody left an employer and went to somebody else, and they're claiming that, information was stolen. What's going to become important perhaps is what did somebody do on a computer at a certain period of time? Again, that's not information that's instantly accessible or available to your average end user. So that computer is going to have to be forensically imaged in order to go back and get all those kind of log files. So you have to be thinking about collection early on, because if this is done improperly from the beginning, you essentially are losing information related to these files down the line. And ultimately, how you produce these files also becomes very important, or how these documents are produced to you. Use the example on the screen because it's here. A file name. Maybe the file name orange-complaint is important for some reason. If I were to produce this to you in paper version, clearly I don't know what the file name is anymore. Or if I produce this to you in a PDF and it's renamed, I don't know what the file name is anymore. So something as simple as the name of the file, which is metadata, can be changed or lost if it's not properly handled from the beginning.
And you can see like a lot of intent things too, Pete, with what you're talking about. If somebody, in your case of employment, oh, I didn't take any company information, doing a forensic image, we can go back and say, well, you clearly copied 500 gigabytes of data on this date at this time to an external drive, and then went back and tried to delete what it is that you did and cover it up. We can see all that through forensic imaging. So I think that's also why that's important, where it's like it might on the surface look like they didn't do anything, but through the logs, we're able actually to dive in through the system logs and actually find that, yes, this drive was attached at this time, at this date, this amount of data was copied, and things like that. So it just shows other ways that we can get to the information sources that we're looking for.
And importantly, if your case deals with data that of that type that might become important, and you're in your meet and confer and you aren't addressing some of these things early on, if they don't preserve it in the proper way, number one, you're going to miss out on the ability to have this evidence. But number two, the more someone uses a device over time, they're going to overwrite information, and maybe not purposely so, but just using a computer every day overwrites logs. And if the logs are important to your case, the longer you wait to have that discussion and get this stuff preserved, you may lose out on the ability to be able to examine that information. So our next sort of step that we're talking about here is getting into data culling. And so when we are considering looking at, all right, how are we going to talk to the other side about what might be reasonable approaches to discovery? We want to understand sources that we may have to go after, who's the people, what's type, general areas of documents. We want to make sure it's matched up to the types of defendants we have, and we want to make sure that the information is preserved properly. And now we're sort of taking this funnel approach where we're like, all right, a step at a time, we're going to try to narrow in on what's important and valuable in our case. And the first one is something that I call data culling. And data culling is really the reason why it's distinctive from some other kind of searching, is that you really aren't focused on what's the context of the documents themselves. You're more looking about characteristics of documents where if you apply them across your data set, you know that this is reasonably going to help you narrow in or expand your discovery to the appropriate timeframes, areas, different things like that. So what are some examples? They're on the screen here. Date range restrictions. If you know that, the relevant time period is, a 1-year period, then everything before and after we can carve out. And we don't need to deal with that. And that is a great way to limit down data sets and focus in on areas, again, or expand it to the appropriate time frame to make sure we're only looking at documents that fall within our relevant time frame. This goes back to why good metadata is important and making sure that, we have date searchable fields. Then we have something called custodian filtering. So in the e-discovery world, a custodian is someone who is responsible for or in charge of a collection of documents. If Sean's a custodian in a case, his emails in his email box, he would be the custodian of those emails. If he was running a department and he had his own set of files, he might be the custodian of those files. It's basically just someone who's overseeing that data set. So again, same type of thing. If we are looking at data across a broader spectrum of an organization, and we have the way to say, look, these people aren't important, these people are definitely important, or here's the ones that are in between, that custodian filtering can really help us narrow in on what's important or not. Document extension filtering. This means looking at the actual documents that we're dealing with from a computer and saying, is it possible this is relevant to my case? Go back to that products liability case I mentioned before, our example, where the manufacturing dates, the suppliers, and distribution is what's at issue in the case. Then do we really care that the marketing company had Adobe files or video files, that they were using for their department? We may not, and just simply by excluding those file types, we're able to say, yeah, we don't need these. We know that just based on the types of files they're not going to be relevant to what we're looking for. And then you have two sort of automatic functions that should always be applied to a data set: deduplication and denist. And deduplication is the idea or the understanding that multiple copies of documents exist across organizations, certainly over and over and over again. So Sean sends an email out to Precise company wide and says, hey, everybody, there's a meeting at 8:00 tomorrow, and we're going to talk about this, this, and this. Well, every single person has a copy of that email in their email box. They may have forwarded on to someone, and now it's a copy of a forward. So what deduplication is looking at is saying, all right, we don't need to deal with the same record 8, 10, 15 times. We're going to only keep one copy. We're going to keep reference that here's all the people who originally had it. But that way we only have to deal with it once when we're actually looking at records. And that's an important way of really culling into what's important for you. And then denisting. And denisting is basically, it's a list of files that are kept, or file types that are kept by an independent third-party organization out there that says, hey, look, this is a Windows operating system file. So unless your case is about how Windows operating system works, there should be no need for you to have to deal with this file. So we're going to find all these file types that fall under this NIST list, and we're going to separate them apart. And again, going back to the meet and confer and understanding, as we're talking to the other side about what is it we're going to have to deal with, who's relevant, what's the areas, these are all sections that you can start getting generally easier agreement upon because it tend to be less areas of contention. And this is an easy way to advance the ball into seeing what kind of data sets you're looking for.
And Pete, just before we move on there, just as a bonus for everybody, let's assume that we didn't have a proper meet and confer, right? And we ended up with a data dump. This section here is where e-discovery can get really expensive or can be done in a smart way. So if everything was collected and preserved properly, all of this is what would be considered in an early case assessment phase. So being able to filter all this data down, back in the day, in the wild, wild west of e-discovery, you would take all this information, you would process it all, you would put it in, you'd spend hundreds, tens of thousands, hundreds of thousands of dollars to get all that information put into a system and then start filtering it. A lot of this stuff can be done before that phase ever happens and can really dramatically reduce the cost of your e-discovery. So if there's one thing that you walk away just as a bonus tip from this, this data culling section and all these things that we can do, the deduplication, the denisting, all that kind of stuff can happen pre-processing. So if you're ever in a situation where you're looking at a potential bill, make sure that all this filtering happened prior to any processing that's going to happen.
Right. And again, these types of things are important because what they're doing is they're allowing you to advance the ball without getting into the sort of more contentious areas, which is kind of where we're heading next in terms of what we're going to talk about. All right, so our next steps.
What's the next steps, Pete?
Yep. So, we take as much of this sort of broad level filtering down as we can, right? And so now we're left with a set of records and whatever the number is that it ends up being. We're now saying, all right, well, how are we going to really look at what is, contextually going to be potentially relevant to my case? Now, there are all kinds of advanced artificial intelligence and, assisted review, all these different things that are out there that are great programs where you can use a computer to help you determine that. What I'm focusing on here for today's topic is more the application of search terms. And, search terms have been around as a crux of defining and coming up to some type of e-discovery agreements for as long as I've been doing this, and they haven't gone away. And it still ends up being, at least in what we see or I see, the majority of the cases end up applying search terms to be able to keep advancing the ball on this. Why? It's because it's understandable. And it's because you get into some of these higher AI type of software platforms. While they're amazing, they can be expensive, and you start to lose the intrinsic value, what you can get out of them if your case isn't huge. So people come back to search terms over and over again. It's imperfect. You can't think of every single search term at the beginning. And importantly, this should be an iterative process. Another area that I often see fights coming out about is that the producing party wants to agree to a set of search terms and say, damn it, that's it. Discovery's over as soon as we apply these search terms. And that's we can't have endless discovery. It's not fair to you as the plaintiff requesting documents from the other side to say, yeah, those search terms look great. Let's just do it. And you're going to just accept what you get back. This should be an iterative process. This should be something where you're allowed to learn a little bit about what it is and how people communicate to give you a chance to apply additional search terms later. Needs to have an end date, needs to have some parameters around it, but doing this in one shot, I don't think is a reasonable approach.
And Pete, a real good example of this actually is I know we all have less time now that the courts have opened up and everything to watch Hulu and Netflix, but there's a phenomenal show on Hulu right now called Dope Sick. And basically it talks all about the opioid litigation and everything that happened with Purdue Pharma and everything like that. And, a good example of this was they knew that this was a marketing driven thing. They knew that it was marketing heavy. They knew that they were putting out false information. They were falsifying reports. They were using all kinds of things, but they couldn't really get down to that, right? So they first went in and they said, we want all the documents for all the marketing related things and things like that. Well, as they started to dive in, that request was denied. It was too broad. They're not going to allow for that. But as they started to go in, they started to come up with terms like double the dose and making the dose unique and just all these different terms that they were actually using internally. And they were actually able to use those to search out some things, to find in some documents, to make reference back to certain materials, to point that the marketing was actually what was behind all this and what was driving all this and everything, which then finally getting approved to get all of the documents related to marketing ever since the launch of OxyContin and the drug and everything like that. So if anyone has time and you're looking for a real world example, it's actually a pretty excellent show, and it's only about 7 or 8 episodes, but it's a really good example of how they were able to break open this case by using it as an iterative process and constantly going back to that well and learning as they were going. As they were learning, they were able to arm themselves with more to actually get the request approved. It was really interesting.
And I think, Sean, you had mentioned to me before that individualized dosages were one of the terms, right? It's a term of art. And you wouldn't know that without going into it and seeing how this is how they describe that. So it's unfair for I think, a party to say, again, we're going to come up with search terms, you're going to agree to them, you're going to accept the documents you get, and then you get no more shots at at refining this based upon what you learned. So
that's a perfect example, Pete, because it was, what was approved was to start everybody at the 10 milligrams. But then when they individualized the dose, what that meant was they had blanket carte blanche to start you at any amount that they wanted to. So rather than the normal progression of 10 milligrams to 20 milligrams to 40 milligrams with the double the dose is what they're originally saying. As soon as they switched to individualize the dose, they were able to prescribe 40, 80, 160 milligrams out of the gate for people, and just, getting people hooked immediately and things like that. But to that point, that was a term of art, right? That was the term that they used. And then once they started diving into that opened up the floodgates to say, wow, they're literally prescribing any amount they want to at any time based on, individualizing the dose.
And so this second bullet point on the slide here is the second punt strategy. Again, sometimes you come into a business and you're like, all right, well, if it's a products liability case and it deals with manufacturing and suppliers and distribution, maybe manufacturer or distribution should be search terms, but you don't know. And you don't know that, or is that going to get a hit on every single document that's out there? And if the other side was being completely forthcoming and assisting in their discovery, they're the ones in the best position to come up with a set of search terms. Now, one of the ways I've seen this agreed to, and I think there is some good strategy in this, is that you have the defendants, the other side, come up with the first suggested use of terms and say, well, why don't you know your documents better? Your client knows your documents better. You know generally the issues in the case that we're dealing with. Why don't you suggest a set of search terms along with a set of custodians and some other things, and we'll work from there. And this gives you the ability to see, hey, how much is what you were thinking matching up with what they're suggesting. And again, by no means is this saying you're agreeing to it. It's just that you're getting the process off rolling, and you're able to see, come up with something that is basically not just a shot in the dark, unless you have some defined information at that point.
So Pete, now let's assume we have some documents, we're working with some documents, right? And the next piece here is, how are we going to search through this data? And there's multiple different ways to search here. If you could just touch on for a minute here, just some of the different ways that we can search through the data and cull the data further.
Right. So, remember, at this point, we're trying to come up with what's a reasonable way of carving through data to get to a production set. And just like anybody who's used Westlaw or Lexis and doing legal research, it's the same kind of general concept searching that we can do across data sets of specific documents. So there's things like Boolean. My document has to have the word hotel and rate within it. And maybe you want to take that a step further and saying, yeah, you know what, that's giving us way too much. We need proximity. The words hotel and rate need to be within 5 words of each other. Or maybe you want stemming where, you want rated and rate and, different things like that. So you say, I want anything that starts with this or ends with this, or exact phrase, which is hotel rate. It has to be that same thing, like individualized dosage. That's a term of art. We want to make sure we're looking for that. And there's more, but these are some basics that you can work with. And these can all be used in conjunction with each other to come up with some searches to say, all right, based upon what we know and the issues in the case, and maybe what the defendants have suggested as an initial set of search terms, and making some changes on your own, here's what we think is a good starting point to see what this comes back with. And again, you're not agreeing that what comes back is what you're going to be produced. This is seeing what's this going to show us, and how do we know that? So this is where we get into the next area of saying, how do we know our search terms are reasonable or not? And so a search term hit report is a critical piece of this whole process if you're using search terms. And what this is going to show you is several things. It's going to show you, hey, if I run the word hotel and I run the word rate across our set of documents, how many of these documents contain this term? And if we look at this report, it's saying there's 50 documents that contain the word hotel and 100 that contain the word rate. And then the next column over says number of documents with family. Well, what's that mean? Well, in the e-discovery world, when we're talking about families, this is typically applying to emails where it's saying, look, we know oftentimes emails have attachments to it. That's considered a family. The email's the parent, the attachments are the children. And so if you get a document that gets the word hit with the word hotel in an email, you probably want the attachments that went with it. Or if you got a hit on an attachment, you want the email and the other attachments went with it. So we need to understand, if we're including whole families in our production and we're not splitting up emails for production, how many is that going to give us? And so that's the starting point, is saying, how many documents are we going to get hit? How many does this have, if we're looking at families? And if we look at that number of documents with families in this example, we say, well, that's great. This is going to give us, 202 documents. Not necessarily. And here's why. And this is something important because it often gets overlooked, but it's important in understanding what is the number of documents we're retrieving. Because at the end of the day, that's how one side or the other is going to argue whether a production's reasonable or not, is how many documents is it pulling back. And so when we look at the cumulative total of the documents, what we have to take into account for this is that there's going to be crossover of these terms between documents. So for instance, if I had 100 documents that had the word rate and 50 that had the word hotel, then I would assume that's 150 documents. Not necessarily. There could be a whole bunch of documents that have both the word hotel and rate in them. So they're getting counted twice in that number. So we want to understand what's the cumulative total for these documents, which in this example is 123. And then if we added their families in, here's 162. And you can even take this one step further and say, and if we dedupe out, make sure that we don't have 8 copies of the same email, what's that going to do? Because I've seen time and again where somebody's like, there's 10,000 documents. This is, ridiculous how broad it is. But when you apply these things down, you cuts it in half and sometimes less. So you really have to be thinking about these elements to search term hit reports in negotiating and determining whether a set of search terms is reasonable or not. I also suggest if you have a list of search terms and the other side's arguing it's still too many, it's going to be a burden to produce it, to review it, or whatever it is, don't choke on the entire list. Maybe you look at the ones and say, look, well, if you take half of the search terms I have, cumulatively, they only are 1,000 documents. Let's produce those or get those moving, and we'll continue to work on the others. And again, going back to this iterative process of being able to work through this.
Pete, let's talk about privileged documents. Obviously, that's something that comes up very often. How do we handle those? What's the best strategy? How do we prepare for those in the meet and confer process?
Right. So if you're the producing party, this is one of your big fear points. I don't want to produce privileged documents. Am I going to waive the privilege? That's going to be used against me. Am I going to face malpractice? This is a sticking point, and for good reason. So there are some ways that you can sort of work your way around the concerns of privilege. Number one is work with the other side about documents that if they contain certain things, they may be presumptively privileged. And presumptively means they're just set aside for the time being from production so that somebody can actually go through and review them and determine if they're privileged or not. So what are some examples of this? Not the word privileged or not the word confidential, because those show up in email footers and things like that. But we're more looking for specifics such as an attorney's name or the domain of a law firm and an email address, or other things like that. Or if it's a product where they're worried about, hey, it's got to be confidential, or there's protected information in there, that's where maybe search terms come into play. But we're looking for things of ways of filtering through and saying, yeah, if this contains at lawfirm.com, presumably your lawyer's on the email, and we can presume it's privileged instead of decide for the time being, so it doesn't jam up your production on the rest of the documents. And then I also encourage all the time to agree to a clawback agreement. And clawback agreements are often used in federal cases, and I see them more in state cases now when there's e-discovery protocols in place. And there's simply an agreement that says, look, if you inadvertently produce a privileged document, you have a right to claw it back. You're not going to be waiving the privilege on it by inadvertently producing it. And that's basically giving them a second layer of comfort of saying, we understand, we're dealing with lots of stuff here. There's a possibility a privileged doc could get produced. We're not going to hold that against you. You'll be able to claw it back. In a real sensitive case where that, you can't unring the bell. Maybe, that doesn't give comfort, but in a lot of cases where it's like, yeah, I shouldn't have produced it, and I don't want this to be considered a waiver of privilege on this issue or this sort of line of communications, that allows them to claw it back. And really, there's not a whole lot of reason why you shouldn't agree to something like this. I guess there could be instances of cases where it's important that you don't, but for most cases, I think that it's reasonable to agree to a clawback agreement, and that helps give some comfort and move the production forward some more.
All right, so we talked about all the different ways that we're going to find the information and ask for the information, ask for what they're going to produce. But one of the most important parts, and I really think this is the second part of the webinar that we want everyone to put the phones down for a second, start to pay attention to, is, let's talk about the document formats. How do we ask for these documents? How are we asking for these documents to be produced to us?
Right. Another area that often gets overlooked, you make progress through searching for documents and, agreeing to searches and different things like that. And then you haven't had any discussion about, well, how are you going to produce these things? And if this isn't addressed up early, this often becomes a big point of contention. Why? Because, you have an obligation to produce documents once. So if you don't like the way the documents were produced and you hadn't addressed this early on, the other side ends up getting an argument for saying, I've already produced this once, I don't have to produce it a second time. This is unfair to me. So addressing this early becomes important, and you want to have this in writing where possible. So what are we talking about? There's really two ends of the spectrum here. It can be something like a paper copy production. They print stuff out and they give it to you. And on the small case or the right cases or whatever, maybe that's perfectly reasonable. But on other cases, it's not. And why? Because I look at that document on the left, I can't tell you what the name of the file is. I can't tell you when it was created. I might not be able to see who the author was of it. I can read it, but there's a lot of important information that's the metadata on the back end that I've lost by accepting it in paper format. The other end of the equation is, hey, you're just going to, collect the documents as they existed on a computer and as a phone or whatever it is. You're going to produce it back to you in the same format. And that is not always reasonable either. And there's a couple reasons for that. A native production requires you to have all the software necessary to be able to read these files. And if you don't have those, that can become problematic. And you see other sides get worried a lot of times about producing or producing documents in native format because there's a concern and a fear that these documents are somehow going to be manipulated and changed and edited whenever it comes time to be used later on. But there are ways to sort of balance these two things and have what sort of gives you the best of both worlds. And so what I'm going to describe here is a typical production format that we see and we think covers a lot of bases for good reason. So number one, you produce an image file format, usually PDF. And why do you do that? You're producing it because people like to have Bates numbers on their documents. You look at a document, you see a Bates number, maybe you want confidentiality stamps, whatever it might be. You can tell where it came from, how it was produced just by a Bates number on a document. And that saves a lot of hassle down the road when you're in a deposition or at a court proceeding or whatever and referencing a document for authentication purposes. You still have to produce some files natively on occasion. I can't take a video file and convert it into a piece of paper or a PDF file. So you have to contemplate that there are some files that need to be produced natively. And there are some files that should be produced natively. A great example is Excel files. They're just usually not designed to be printed. So if you print them, which is the equivalent of converting them into an image file, you're going to get a lot of junk pages. They're going to be frustrating. You're going to have a 500-page image file that was an Excel file that doesn't look meaningful for you at all. So you want to contemplate that there are native files that are going to have to be produced. Ideally, these next areas, you want to get them even if you're not going to be using a database, for instance, to search all this stuff or manage it. Even if you don't ask for this stuff up front, you're not going to have that option later on. And to go back and ask for this stuff supplementally to your production is, good luck on that. So I think you're better off asking for these things. It doesn't cost any more money for someone to produce it. if they've managed these files in the proper way. So you might as well have them whether you use them or not. And so what are those? Those are the metadata fields. Maybe you need to know what the date created was and the authors and email. Certainly it's important to know the tos and the froms and the email subjects and things like that. A load file ties all this stuff together. So it says, hey, you PDF file belong to these metadata fields. So when I search over here, I'm going to be looking at the appropriate file. And I know this email belongs with these attachments. So it keeps all that stuff together. Those things give you the ability to use a database program, to use software to help you search these things later on, if you so choose to do it. So thinking about that format of production early on and trying to get some agreement in it is important. Otherwise you're going to get this stuff in the least useful way possible.
All right, Pete. So we're hitting into the home stretch here. So obviously keeping track of all this is really, really important. And I know there's some specific ways and even some example documents and things that we use in terms of the ESI protocol agreements and production agreements and things like that. So could you just talk a little bit about that?
Yeah. So that we aren't reinventing the wheel here. We've done so many of these cases over the years where, there's been agreements, or we've helped write the agreements or tweak the agreements or whatever it might be, that, we have a library of these things at this point, and they've changed over time. And, some are relevant to, cases that deal specifically with cell phones, and others are relevant that deal with, broader perspectives or a combination of all the above. So typically what comes out of the end of a meet and confer session is it some type of ESI protocol or production agreement. And it's outlining, hey, all right, here's what we're going to do. Here's how we're going to do it. Here's the steps that are going to happen. And oftentimes has deadlines with them so that you know what to expect when. And in this process of doing this, usually as part of the agreements are some types of production trackers that are showing when documents were produced, privilege logs, and, so you can contest privilege if you want, and making sure that all the pieces that were supposed to happen have happened. And so at the end of your meet and confer, ideally, this is what you're coming away with, and you have something that is defining how you are approaching the discovery process that has been, put together in writing. And the courts love to see this because it's taken, a lot of fighting off of their plates and has something that you can point back to make sure it's being done properly. So I would suggest if you have a need for something like this or need certainty of some type of documentation, reach out to us because we have so much of this stuff in our library already. And I know we've mentioned this in the emails we sent to everybody, but for anybody who participated on this webinar, if you want to have a meeting to sort of sit down and talk about the specifics on a case that you have, it's a free seminar or a session with me to be able to go over that and talk specifics of your case. Obviously, I think you're seeing from what we talked about, every case can be different. The issues and the type of stuff you're dealing in your case are really going to drive what you should be considering. So I would certainly, welcome the opportunity to talk to anybody, at the conclusion of this webinar to sign up and talk about cases you may have in your pipeline and discuss, what you should be considering at that point.
Yeah, thanks so much, Pete. And we actually, so we have three, first and foremost, thank you, everybody. Actually, we had everybody stay the entire duration of the webinar, which is impressive. We had a nice turnout here. So we appreciate you spending your afternoon with us. So the three next steps of what you're going to want to do in an email, you are going to receive an email to download what we call the Plaintiff's Guide to E-Discovery. It's something that we put together pretty recently that covers a lot of this information, has a lot of hit points, goes a little deeper into certain areas. The next piece that you're going to do is everybody that attended this webinar gets their 30-minute meet and confer consult with Pete. Even if you have, just general questions or something like that, please use that time. Pete's, as you can see, has attended hundreds of these conferences and has been involved in countless cases. So it can really help, guide you in the right direction. And then at the conclusion of your 30-minute consult with Pete, we can share with you some of these production agreements and some of these templates. We can save you a lot of time by going through these and just being able to use these as a template. So for spending your time with us and to show our appreciation, we'd like to offer you those 3 free things. Thank you again for spending your afternoon with us. We're going to send some follow-up emails. You'll get an email about a recording of it too. So if you missed any of this, don't worry, you can jump back in. And we hope everyone has a wonderful day. Take care.
Thanks, everyone. Bye-bye.